Hello, everyone.
I can hear you, Manjo. That's Vivian. I can't hear you now.
Still can't hear you, Manjo.
Hello, can you hear me now?
Yep.
Okay, good. Okay. And you can see me. Okay, I don't know what happened there. Okay, good. Fantastic. So sorry about that. I've had a problem with the internet, I think. Okay. So we'll proceed. I'm just going to do the share screen now. So we will be discussing the week 7 topic on state and federal relations. But before we go there, is there anything that you would like to ask? If you happen to have any questions, anything you'd like to clarify before we start discussing the topic? Questions,
Manjo,
comments?
can I ask?
Go ahead, yes.
Can I ask a quick question?
Yeah, hold on.
I'm just wondering.
Wait, hold on. If I do this, can you hear me? Can you hear me still? Okay, good. Yes, go ahead. Okay.
Sorry if you've already said this, but I'm just wondering when our course participation grades will be up and when the legal memo will be back, results will be back?
For the legal memorandum results, it will take me 3 weeks to mark all of those. So that's 3 weeks from the due date, which was, I think, September 4. So we count 21 days. That should come out on September 21. No, sorry, September 25. And for the marks for the group participation, give me until this weekend. I've got a lot of catching up to do. but they should be up by Saturday or Sunday of this week.
Great, thank you.
Okay, any other questions there?
Am I able to ask a question about this
Go.
week's topic?
I like you want some clarification on this week's topic, or
It's I noticed something, and because I'm in New Zealand and we pay tax, it was just I just wanted to ask how that came into it.
yes? Okay, let's see if my concern. I think we had there was a comment we had the last time that there was a concern about us talking about other topics which were not meant to be covered in the week, and that causes confusion to others. And so my concern is if we start discussing the weekline topic now, it may just end up confusing others who may not have actually read it. So if you don't mind,
Okay.
you could either send me an email and I'll probably post it in the discussion forum, or if you could just hold off, try to remember that, because I want to avoid the confusion, and mainly also because we're actually using a Zoom license, which will then be used by Wayne at 7. So I want to make sure that we cover all the 4 questions for tonight's session.
Okay.
So I hope that's okay. Yep. Okay.
Yeah, that's fine.
Okay. Thank you. Anything else? None. So I guess we could proceed. So for tonight, we hope that after we go through the discussion questions, you should then be able to discuss and explain the scope and limits of Commonwealth and state legislative powers and the subject matters over which they can legislate exclusively and concurrently, discuss and explain the conflicts in and resolution of Commonwealth and state parliamentary relations, discuss and explain the expansionary doctrine in the engineer's case and the constraints of Commonwealth legislative power in interfering with state governmental powers, and then cite and discuss key judicial decisions that elucidate the Commonwealth-state legislative relations. So let's begin with the first discussion question that we have. Can I have a volunteer who can read the question for us?
Yeah, I can do that, Mando.
Patrick, thank you.
A concern with activities that harm the environment, the Commonwealth Parliament passed the Good Farming Practices Act, Commonwealth, that requires farmers to observe certain good farming practices and provided penalties for any violation of the Act. Julian Blogg was found, after investigation, to have undertaken farming practices that violated the Act and penalised with a fine. Advise Blogg on whether his legal challenge is likely to prosper.
Okay, in 30 seconds, yeah, thank you, Patrick. In 30 seconds, can I ask everyone to put his or her answer in the chat box, whether you think the legal challenge, assuming that Julian Blogg challenges the constitutionality or validity of the specific Commonwealth Act, can you indicate in the chat box whether you think his legal challenge will prosper? So kindly post your answers in the chat box. If it's a yes, say, please provide an explanation why you think it might or might not prosper. So please provide a reason why you think it might or might not prosper. Okay, so we've got some saying that the act is valid. So when you say no, this legal challenge will not prosper, okay. Some are saying the legal challenge will prosper. Okay, so would somebody be willing to take the floor and explain why you think the legal challenge will prosper or not? Can we get somebody to explain it? Okay, can somebody do that for us? Can somebody explain why you think the legal challenge will or will not prosper? Can somebody do it for us? Volunteers?
I'll have a go, Manjo. Peter
Go
Ritchie
ahead.
here.
Thank you, Peter. Yes.
Okay, my understanding is that I'll read my answer.
Yes.
The main issue to be understood in this scenario is whether the Commonwealth power has the power to create laws relating to the environment. Now, under the Constitution, the Commonwealth Parliament has the power to create laws for the peace, order and good government of the Commonwealth in areas which fall under the heads of power of Section 51. The environment does not fall under these heads of power, so laws related to this area would normally fall under the states. However, the engineer's case laid the framework for the expansion of the Commonwealth Parliament's ability to create laws which do not fall directly under the heads of power for which they are responsible. The Commonwealth Parliament can, under the ruling of the engineer's case, exercise power over areas such as the environment, provided that it can be legitimately linked back to an existing head of power for which they are responsible for. It would be a legitimate use of the power for the Commonwealth Parliament to link this back to external affairs as per Commonwealth and Tasmania from 1983. So, provided the Commonwealth Parliament has used an appropriate head of power, his challenge will fail.
Okay, so we got that. Did we get the answer from Peter, which was perfect? It was quite elaborate and was quite complete. I think that was clear enough. So, so Peter, can I just ask you to summarize your answer again for the benefit of everyone?
Oh, okay. Effectively, what I've said is that the environment doesn't fall under Section 51 of the Commonwealth Parliament, so it would normally fall to the states to provide laws around the environment. However, under the engineer's case framework, if you can legitimately tie it to one of the existing heads of power through something that relates to it, well, you can then create a law. The Commonwealth Parliament can create a law governing that area.
Okay, so I think that's clear. Does anyone have a question there? So if I may be allowed to paraphrase what Peter Richard said, which, as I said, that was an HD answer. It was a high distinction answer. Thank you, Peter. So what Peter was pointing out was that as far as the powers of the Commonwealth Parliament are concerned, the powers of the Commonwealth Parliament must be based on Section 51 or one of the provisions of the Constitution. So in other words, if the Commonwealth Parliament cannot cite a specific provision that provides it the power to legislate on a specific subject or head of power, then that is beyond the power of the Commonwealth Parliament to legislate. So in other words, all other fields of law belong to the state parliaments, except for those which the Constitution would expressly or implicitly provide to be within the scope of the Commonwealth power to legislate on. So I don't know if I made things more confusing. So that should be quite clear. But if we follow the case of the engineers, which is Amalgamated Society of Engineers versus Adelaide Steamship Company, even if a particular field or even if a particular subject is not one of those which is covered under Section 51 of the Australian Commonwealth Constitution, if the Commonwealth Parliament is able to cite another head of power, such as what pointed out by Peter, which could be about external affairs, or it could be about trading corporations, then it is possible in that case for the Commonwealth Parliament to legislate equally on a subject that would have fallen exclusively to the states to legislate on. So if there is a head of power under which the Commonwealth Parliament is able to legislate on, it can then incidentally legislate on a matter which should have fallen exclusively to the state. So in this particular case, as Peter pointed out, if it could be based on, let's say, external affairs or perhaps the trading of corporations and so on, then in that case, the Commonwealth Parliament may validly legislate on the area of good farming practices. If there is another head of power under Section 51 on which the Commonwealth Parliament can base its power to legislate on the specific subject of good farming practices. Okay, so that was good. Thank you very much, Peter. I think you explained it better than me. Okay, we'll move on to the next question unless there's anything that somebody would like to clarify.
Yeah, Manjo,
Yes.
Paul here.
Yes, Paul.
Just a query on that.
Okay.
In the Tasmanian Dam case,
Yes.
wasn't the nexus the fact that it was there was a convention and that brought it under the external affairs? I don't see I sort of can't see a connection here. I agreed with Peter up until the last bit. I sort of don't see the connection between external affairs and this particular case.
Yes. The simple answer of Peter was that the legal challenge of blog is likely to prosper. So the simple answer of Peter was that blog's legal challenge is likely to prosper. So in other words, the Commonwealth Parliament does not have the power to legislate on an area such as good farming practices, because farming practices or agriculture is not one of those fields where Section 51 provides the Commonwealth Parliament the power to legislate on. So that's the simple answer. Blog's legal challenge is likely to prosper because it is not within the power of the Commonwealth Parliament to legislate on an area such as farming or agriculture. Okay, so we begin with that basic answer.
Okay.
Yes, but Peter was explaining that,
thank you.
Yes, but Peter was explaining that assuming that the Commonwealth Parliament actually legislated on the basis of a treaty that the Commonwealth Executive may have entered into, and that specific treaty may have talked about farming and agriculture, then the power of the Commonwealth Parliament would have been based on its external affairs power under Section 51. And because there is now a basis for the Commonwealth Parliament to legislate, which is external affairs, and as a corollary to that, it legislates on the subject of good farming practices, then following the engineer's case, that even if good farming practices per se is not one of those heads of power which Section 51 has invested the Commonwealth Parliament to legislate on, the Commonwealth Parliament would still validly legislate on good farming practices in that specific scenario by hinging its legislative power on the external affairs power which is given to the Commonwealth Parliament under Section 51. Was that clear enough? So for as long, in other words, the engineer's doctrine has an expansionary effect. For as long as the Commonwealth Parliament can base its power to legislate on one of the heads of power, it may then validly legislate on another field or subject matter, even if that field or subject matter is not one of those which was granted under Section 51 to the Commonwealth Parliament to legislate on. And this is why...
But doesn't there have to be some...
Go ahead.
Sorry. Doesn't there have to be some connection? That's what I'm concerned about.
So you're saying, for example, let's say...
Some real...
If by connection you're asking, should there have been a head of power on which the Commonwealth Parliament legislated on? Would that be the question? Or are you asking the question of whether or not, let's say the external affairs power, there must be a clear link between external affairs power and agriculture as a connection? Is that the question? Because those are two different things.
Yes, the latter.
Oh, the latter. If you follow the engineer's doctrine, there doesn't have to be a clear nexus. And this is the reason why in one of the dissents of the justices, he was actually saying that because Section 51 provides the Commonwealth Parliament the power to tax, then if the Commonwealth Parliament therefore passes legislation concerning taxation and in the process legislates on something else, which could be agriculture or the environment or education. So even those fields of power, even if they do not actually belong to the Commonwealth Parliament to legislate on, meaning they exclusively belong to the states. Because the Commonwealth Parliament has legislated on a head of power, which is given to it under Section 51 of the Constitution, it can then legislate on something else or everything else. So that is the expansionary consequence of the engineer's doctrine. So was that clear?
Okay, thank you.
Okay.
Yes,
So-
thank you.
Okay. So as Vivian pointed out, agriculture would be a state matter, as you know, the same manner that education would be a state matter, or the environment would be a state matter. Ali is good to point out Section 107 and Section 118, where it is possible for the state actually to ask the Commonwealth Parliament to legislate on a specific subject. So if, let's say, there is if one of the states, let's say Western Australia, asks the Commonwealth Parliament to legislate, for example, in the field of agriculture, then in that case, on the basis of that request, it would then be possible for the Commonwealth Parliament to legislate on a certain field upon the request of a specific state parliament. Okay, so let's move on to the next question. Can we get a volunteer again to go through that specific question? Discussion question 34.
Yeah, I can do that, Manjo.
Thank you, Peter.
That's Patrick.
Sorry, Patrick, yes.
To strengthen Australia's image as a producer of green and environmentally friendly agricultural products and enhance Australia's exports, the Commonwealth Parliament has passed the Green and Environmentally Friendly Act, Commonwealth, that set out rules on agriculture and fisheries practices. Julian Blogg was found after investigation to have undertaken farming practices that violated the Act and penalised with a fine. He challenged the validity of the law, advised Blogg on whether his legal challenge is likely to prosper.
Okay, so can I again ask you to give your answer in the chat box? Okay, we got an answer there from Anthony. I was trying to get an answer here and post it on the screen. Hold on. But it keeps on moving. So this one is from, was it from Peter? Yes, from Peter Ritchie. Okay, so I think this is a good way of looking at an answer to a question when it pertains to whether or not the Commonwealth Parliament has the power to legislate on a specific subject matter. You always begin by asking, is this a subject over which the Commonwealth Parliament has been granted by the Constitution, specifically, for example, Section 51, the power to legislate on? That is always the basic question. Is there a head of power on which is there a head of power on which the Commonwealth Parliament may legislate on this specific subject? So that's always the first question you ask. Okay, so is there a head of power on which the Commonwealth Parliament may legislate on a specific subject? So that's the first question. If not, is there another head of power on which the Commonwealth Parliament may legislate on, and in the process Okay, so I think that there is a two-step process we need to look at when we examine the power of the Commonwealth Parliament to legislate on a subject. The first question we always ask is there a head of power specifically, for example, under Section 51, on which the Commonwealth Parliament may legislate on a specific subject? So that's the first question. If the answer is yes, then we don't have a problem. We know that that legislation would then be valid. But if the answer is no, did somebody want to say something? But if the answer is
yes, ma'am.
yes, go ahead. Kylie.
I just wondered if I could ask a question on the second step.
Yes, go ahead.
From what you said in the answer to the previous question,
Yes.
so the link to that alternative head of power doesn't have to be particularly strong. Is that right? Is
Yes,
that what
that's
you're
right.
saying? The engineer?
Yes. It doesn't have to be strong.
Okay, thanks.
Yes. Let me just make a little bit of a clarification though, because in general, the link between the actual head of power, which the Commonwealth Parliament may legislate on, and that other field over which the Commonwealth Parliament has no power to legislate on, the link as in general does not have to be strong. Okay, so in general, the link does not have to be strong. So, for example, if the Commonwealth Parliament passes a law on education and bases its power to legislate on education, let's say by citing its power to legislate on external affairs, or its power to legislate on trading and commerce with other countries. Okay, so the tenuous, the connection, if you will notice, between those two fields of power would be quite tenuous and remote. But still, because of the expansionary consequences of the engineer's doctrine, that would still be valid. Okay. Now, if you notice, therefore, that there are two ways by which you may classify the heads of power of the Commonwealth Parliament under Section 51. Most of the heads of power would focus on persons, such as aliens, or it may focus on things, which could be railroads. It could focus on certain situations, and so on. There's another classification of heads of power, and usually this would relate to a purposive aspect of the head of power. A specific example of this will be, for example, military defense of the Commonwealth. Okay, so the aspect of the head of power concerning military defense is purposive. There is kind of a purpose for the specific head of power. Now, this one, because it has a purposive effect, there is a requirement that when the Parliament, for example, passes legislation basing it on a provision that has a purposive effect, there is a need for a connection between a stronger link or a stronger nexus or connection between that specific head of power, which is purposive, and the other power, the other field over which the Commonwealth Parliament is legislating on, for which it has no power under Section 51 to legislate on. So, for example, if the head of power were military defense, and then the Commonwealth Parliament passes a law concerning education. Okay, can you see the example now? Military defense, over which is a head of power, which the Commonwealth Parliament may validly legislate on, and the other field of power, the other field over which the Commonwealth Parliament is legislating on might be education, or it might be agriculture. The requirement under the rule of Communist Party of Australia is that there must be a nexus or even a proportionality between the head of power on which the Commonwealth Parliament legislated on and that other field that the Commonwealth Parliament legislated on and over which it actually has no power to legislate on under Section 51. So can we see the difference now? If the provision has a purposive character, such as military defense, so the purpose of that provision is really the defense of the Commonwealth. Once the Commonwealth Parliament legislates, comes up with a legislation that uses as a basis the provision on military defense, then it will be necessary for the law to show a clear nexus and a clear proportionality between the legislation over which the Commonwealth Parliament has no power to legislate on and military defense. So the question arises, therefore, what is the connection in that example that I gave between the defense of the Commonwealth and education or agriculture? And the other question would be, would the legislation on fisheries or education, for example, would that be proportionate to the defense of the Commonwealth? If the answer is no, then that law would be invalid. So, in other words, it goes to the other more basic question. If the Commonwealth Parliament, for example, passes a law which says that in defense of the Commonwealth, it will investigate the visa or the power of people to remain in Australia. So let's repeat that. Let's assume that the Commonwealth Parliament, citing Section 51, subsection 6 on military defense, passes a law which enables the Australian Federal Police to stop every single person in Australia to determine if they have the right to remain in Australia. So let's assume that's the question, okay? In that case, the basic question that will need to be asked is, it's not sufficient, therefore, to say that the Commonwealth Parliament has the power to legislate. It's not sufficient for that legislation to be valid simply because it can be covered under one of the heads of power, which is military defense. There is another question that has to be asked, and that is whether or not there is a proportionality between military defense and the need to require every single person in Australia to be stopped to determine if they have a right to remain in Australia. And I raised this point because I think 2 weeks ago, there was a problem somewhere, was it in Melbourne, where on the request, I think of, was it the Melbourne, or was it Victoria? Yeah. So I think on the basis of the request of the Victorian state executive, there was an attempt on the part of the Border Police and the Australian Federal Police to actually stop every single person within a certain area to check if they had a valid right to remain in Australia. Had there been a law to that effect, the question concerning proportionality would have been raised. Okay, so if the head of power is purposive, there is a need to show a connection or a nexus, as well as a question as a question of proportionality. And the case that would show this would be the case of Australian Communist Party of Australia, where it was asked whether or not it was within the power of the Australian Commonwealth Parliament to actually prohibit membership in the Australian Communist Party, citing the military defense power of the Australian Commonwealth under Section 51. And the High Court ruled that the prohibition of membership in the Australian Communist Party was not proportionate to the defense of the Commonwealth, and therefore, in that case, the law was declared invalid. So from Audrey here, yeah. So for Audrey, if it can be shown that in the example that we have, if it can be shown that the Commonwealth legislated on the subject as a way on the basis of its attempt to regulate exports for trade and commerce with other countries, then it would be valid then, by extension, for the Commonwealth Parliament to legislate on agriculture and fisheries practices as well, because there is a head of power on which the Commonwealth Parliament is able to validly legislate on. Now, for Michelle, but it's only for its image. How is that close enough to exports? Yeah, that's exactly the point, Michelle. In general, if the provision is not purposive, if it doesn't have a purposive character, the connection or the nexus does not have to be very close. So you might question, what is the connection or the nexus between exports and agriculture? You might say that the connection is quite remote. The mere fact that the connection between exports and agriculture and fishery practices might be remote will not invalidate the law. The crucial point there is that there is a head of power on which the Commonwealth Parliament has legislated on the subject, and that is based on the engineer's doctrine. The exception will be if the basis of the Commonwealth's Parliament to legislate on a subject is on the basis of a provision which has a purposive character, because then if that provision or that head of power has a purposive character, it is crucial, it will be necessary for there to be a showing of a nexus or a close nexus or a close connection between the two fields, as well as a proportionality between the head of power on which the Commonwealth Parliament is legislating and that other field over which it actually has no power to legislate under Section 51. Okay, so we could move on. Okay, we could. Discussion question 35. Can I get a volunteer again?
Yeah, I can do it, Menjo.
Thank you.
Oh, go, Patrick.
Patrick. Yes.
In order to promote transparent and ethically sound business practices, the Commonwealth Parliament passed the Transparent and Ethically Sound Business Practices Act, Commonwealth, that sets out rules and guidelines to be followed by Australian trading and financial corporations, partnerships and sole traders. Colin Goodfind was charged with violating the Act. He challenged the constitutionality of the Act on the ground that the legislative power of the Commonwealth Parliament under Section XX is limited to laws with respect to foreign corporations and trading or financial corporations formed within the limits of the Commonwealth and excludes sole traders. Advise Goodfind on whether his legal challenge is likely to prosper.
Okay, thank you, Patrick. So can I again ask everyone to post his or her answer in the chat box? So from Peter Haycock, his challenge would prosper. Okay. The others? Yes, from RG. So the answer seems to be yes. How about the others? Okay. Okay, so the answer seems to be that it will not prosper because sole traders is not a subject. under Section 51 over which the Commonwealth Parliament can legislate on. Do we have a contrary opinion here? Do we have a contrary opinion? Can somebody say that?
Yes,
Can somebody argue that the legal challenge actually will not prosper?
I will say it won't prosper. It's Vivian.
Yes, Vivian?
Can you hear me?
Yes, I could.
Okay, basically the Commonwealth actually has power to legislate over the Commonwealth matters such as the foreign corporations, etc.,
Yes.
as well as the company, things like that. Now, it does exclude sole traders, but this legislation is just not talking about sole traders. They're actually talking about all these other items that the Commonwealth can constitutionally legislate on. Therefore, it is actually just part of that legislation, and it'll be upheld because it isn't. It's like the engineers. How far can you go? I think it will actually be valid.
Okay. That actually is the correct answer. So the correct answer is that which has been stated by Vivian. On the basis of the engineer's doctrine, this law would be valid because there is a head of power under which the Commonwealth Parliament can legislate on. So because the Commonwealth Parliament can validly legislate on trading and financial corporations which have been formed within the territory of Australia, it can then by extension also legislate on a field such as sole traders. So if the legislation itself pertained only to sole traders, then a legal challenge would prosper. But because in this particular case, the legislation of the Commonwealth Parliament also included trading and financial corporations which are formed within the limits of the Commonwealth, the Commonwealth Parliament could then validly legislate as well on sole traders, even if the field of sole traders is something that would have been within the competence solely of Australian states. So the answer is it will not prosper, the challenge will not prosper on the basis of the expansionary doctrine of the engineers case, Amalgamated Society of Engineers case versus Adelaide Steamship Company. So will that be clear enough? Questions? Yes, so for Martin, sole traders is just one part of the legislation. The other part would be trading and financial corporations, trading formed within the limits of the Commonwealth. In that case, that gives it validity. The fact that there is a head of power on which the Commonwealth Parliament can legislate on, then it can then legislate on another field, even if in that specific field is not a field that Section 51 has given the Commonwealth Parliament the authority to legislate on. So from Audrey, the law is not invalid simply because it legislates on the topic and the power of the states. Okay, yep, thank you, Audrey. Any questions before we proceed to the last question? Anything you'd like to clarify there? No? Was that clear? So I'm hoping you're able to see the importance of the effect of the case of the engineers, Amalgamated Society of Engineers versus Adelaide Steamship Company. I hope you can see the expansionary consequence of the engineers case. Let us just clarify that the limitation of that will be if the law passed by the Commonwealth Parliament has the effect of impairing the governance or the operations of the states. So that will be a limitation though. So the limitation is, as the High Court has pointed out, of even if the Commonwealth Parliament may have the power to legislate on a certain subject, Section 51 is clear that the power of the Commonwealth Parliament to legislate is subject to the Constitution. And the High Court has pointed out that even if the justices in the engineer's case made a literal interpretation of Section 51 of the Constitution. The High Court later on made it clear that even Section 51, because of the provision there, or the clause there, that it is subject to the Constitution, there is an assumption that there is in fact a limit to the power of the Commonwealth Parliament to legislate. And at least there are at least three limits there. One is that power is the power of the Commonwealth Parliament is to legislate is limited by certain freedoms that are guaranteed expressly or implicitly by the Constitution. So that could involve the implied freedom of communication. That would be a clear constraint. The other clear limitation would be the separation of powers. So if you will remember, under the Boilermaker's doctrine, even though there is nothing in the Constitution which explicitly provides that other courts which are not part of the federal judicature may not be given judicial powers, or that the courts which are part of the federal judicature may not be given executive powers, even if that is not explicitly provided in the Constitution, it is implied under the Boilermaker's doctrine that is a clear constraint on the power of the Australian Commonwealth to legislate on. The third constraint is that although the Australian Commonwealth has the power to legislate on the subjects under Section 51, there is a limitation in the sense that the Commonwealth Parliament cannot pass a law that would impair the operations or governance of the states. So where the legislation would impair the operations of states, then in that case, that legislation would be invalid even if it falls within one of those subjects over which the Commonwealth Parliament could legislate on under Section 51. Okay, so in other words, the engineer's case, in terms of statutory construction, made a literal interpretation of the Constitution. So there was an attempt to literally apply the provisions of Section 51. And so the justices were saying, because there is nothing that expressly states in the Constitution that the Commonwealth Parliament cannot legislate on, let's say, the issue of, in that case of the engineer's doctrine, there was nothing in the Constitution that restrained or prevented the Commonwealth Parliament to legislate on a subject that enabled a quasi-judicial body of the Commonwealth Parliament to pass industrial awards that affected the certain entities owned by Western Australia. So there was no limitation in that sense. Then the High Court ruled that the legislation was valid. But that literal interpretation has now been changed in subsequent rulings of the High Court, where the High Court said that there are in fact implicit constraints on the power of the Commonwealth Parliament to legislate. And those, the three that I mentioned, one was related to explicit or implicit guarantees of certain freedoms. The second one would be the issue of separation of powers, which is implicitly guaranteed by the Constitution. And the third constraint is the restraint on the power of the Commonwealth Parliament to pass laws that would impair the operation of state governments. So from Ali, but Kirby just stated that Section 51 is interpreted broadly in the case of states that have the powers on the subject matter. In relation to the power of states, it should be clear that there is no requirement that they have to cite a specific provision in the Constitution over which they could legislate on. As a general rule, let me be clear, as a general rule, state parliaments could legislate on everything except those which has been given exclusively to the Commonwealth Parliament. So in fact, state parliaments could legislate on the fields which are under Section 51. So state parliaments could legislate concurrently with the Commonwealth Parliament on the fields which are under Section 51. The only fields or the only subjects over which state parliaments cannot legislate on would be, for example, the one which is in Section 52, which concerns, for example, the seat of the government of the Commonwealth. So except for those fields which have been exclusively given, except for those fields which have been exclusively given to the Commonwealth Parliament, state parliaments have the freedom to legislate on everything, including those which are in Section 51, for as long, generally, as the law relates to activities or matters within their territorial limits. Oh yeah, okay. So we'll go on to the next question. We've got about 4 more minutes. Can Peter, can you again read this question for us? Patrick, rather.
Yeah, I can do that.
Yes.
In order to promote transparent and ethically sound business practices, the Commonwealth Parliament passed the Transparent and Ethically Sound Business Practices Act that set out rules and guidelines to be followed by Australian trading and financial corporations. The Act provides for stiff penalties for any violation of the Act. The Act states all Australian trading and financial corporations must comply within this Act within 3 months, except those in Tasmania which must comply within 2 years. XYZ Corporation was charged with violating the Act. It seeks to challenge the Act, advise the XYZ Corporation on whether its legal challenge is likely to prosper.
Okay. Can I ask you in the next few seconds to answer whether or not the legal challenge is likely to prosper? Again, post your answers in the chat box. So from Anthony, yes, the legal challenge is likely to prosper. Okay. Okay, good. Can you explain, can I ask you to explain why it would prosper? So from Tasman, it's so difficult to copy here. Okay, from Audrey, the law is discriminatory to Tasmania. Okay. Oops, hold on, what happened there? Okay. There is an argument that could be made, and I'm just going to do this quickly because we're running out of time. Wayne takes over this license. It can be argued that the law is actually discriminatory in favor of Tasmania because while other trading and financial corporations of other states are required to comply within 3 months, it discriminates in favor of Tasmanian trading and financial corporations. That discriminatory practice or even the attempt to give a preference to Tasmania is actually invalid because of the decision in Actors and Announcers versus Fontana, as well as the clear provision of Section 99 of the Constitution, which prevents the Australian Commonwealth Parliament from giving a preference to any state. So both under the decision in Actors and Announcers versus Fontana films, the High Court has ruled that it is not possible, it would not be valid for the Australian Commonwealth Parliament to discriminate against a state. And Section 99 is also clear that there can be no preference given to any state given by the Australian Commonwealth Parliament. So the answer is it is not valid because it either discriminates against a specific state or discriminates in favor of another state, which means therefore there is a preference that has been given. Okay, so we've got 1 minute to go. Will there be any other questions before we end tonight's tutorial? And then we'll have another tutorial tomorrow which focuses on week 8. Any questions? None?
Are we going to do the last question, Manjo?
That was the last question, in fact. This was the last question. We only had 4 questions and we covered that. So we've covered all the 4 questions. We only had 4 questions actually in tonight's tutorials. And we've answered all those 4. Okay, so I'm gonna have to say goodbye because it's 7 and Wayne takes over this license. Okay, good night everyone. Thanks again for joining us. See you soon. Bye.